Please. We lead the nation in fatalities. And here you are charged with 2 open DWI seconds. Applications, I'm telling you, Amazon will hire anyone with 3 legs and a partial heartbeat. Go to Amazon. I'm telling you, they hire everyone. They need more.
Welcome in, because today's courtroom session is one of those dockets where everything collides at once. Guns, drugs, job struggles, probation violations, and judges trying to stop people from completely wrecking their futures. Judge David Fleischer wastes no time setting the tone here. Before we even meet the first defendant, he's already hammering home the big theme of this entire hearing: responsibility. Notice how quickly the judge pivots from deadly consequences on the road to employment advice. That's not random. Courts see the same cycle every single day: unemployment, bad choices, new charges, repeat appearances. Judges often know that without stable income, defendants slide right back into the same situations that brought them here. And that Amazon line? It sounds humorous, but it's strategic. Judges sometimes use humor or blunt realism to break through denial. He's basically saying excuses are over, jobs exist. Now the responsibility shifts back to you. Throughout this video, watch how often employment, structure, and accountability come up. This isn't just punishment court, this is intervention court. But intervention only works if defendants take the lifeline. And here's the big hook for today: several people in this courtroom are getting second, third, even fourth chances. The real question is, who actually uses them? Stay with us, because the stakes escalate fast.
Edward Dixon. Mr. Dixon, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please don't say anything.
Yes, Your Honor, on May 20th, 2024, in Harris County, Texas, officers observed a vehicle traveling 58 miles per hour in a 35-mile-per-hour zone and attempted to do a traffic stop. The vehicle evades for 2 miles over 5 minutes, driving through a retention pond before getting stuck. The driver, defendant, stated he had a firearm inside the vehicle and that he evaded because he was scared. Officers recovered the firearm and 6.2 grams of marijuana from inside the vehicle.
Mr. Dixon, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, sir?
Yes, sir.
Can you run this license, please? You have valid liability insurance in your name. Before you drive, I want to see proof of it.
Yes, sir.
Because I'm making it a condition of your bond not to drive without a Texas driver license and liability insurance in your name. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well.
This moment is subtle but extremely important legally. The judge is stacking bond conditions specifically designed to prevent a repeat offense. Think of bond as freedom with rules attached. Break those rules and freedom disappears quickly. By removing weapon access and requiring proper licensing and insurance, the court is essentially saying, we're giving you a chance, but we're watching closely. What many viewers miss is how generous PR bonds actually are. A personal recognizance bond means the defendant is released without paying money up front, trusting they'll return to court. But once someone picks up additional charges, that trust disappears fast. Notice the judge's tone too: firm, not screaming. That's often more effective. He's drawing boundaries without theatrics, signaling seriousness. And the key takeaway here: bond isn't the end of a case, it's the beginning of accountability. And this defendant's next decisions will determine whether he stays free or heads back into custody.
You were given a PR bond. You're now also charged with a felony. Do not pick up any new cases. Otherwise, I will revoke this bond and I'm going to make it high. You will not get any more PR bonds. How old are you? What do you do for a living?
Zelda, Your Honor.
Prior to you driving, I want to see proof. How much money do you make a month, sir? How much? And who do you live with?
Okay.
We're going to give you we're going to reset your case to give you time to hire a lawyer, sir. So I'm going to have you go to Victoria. We're going to have you sign a reset. After that, we're going to create bond conditions for you. We'll have you sign the bond conditions, then we'll let you go. When you come back, please have a lawyer, sir.
There's no driver
No driving without Texas driver's license and liability insurance, and then no weapons, please.
All right, case 15, Johnson.
We'll wait for you to do it, Kevin. So. Johnson. Okay. Mr. Johnson, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Now we meet another defendant, and immediately the tone shifts because criminal history enters the conversation. Past convictions matter enormously in court. The judge hears prior weapon charges and assaults, and suddenly this isn't just a possession case. It's a pattern. Courts look for patterns because they predict future behavior. Notice how the judge repeatedly warns Johnson to stay silent. That's crucial. Anything said in court can hurt later. Defendants often talk themselves into deeper trouble. Then comes the employment conversation again. Judges see idle time as danger time. Without work, people often fall back into risky environments. Engagement question for viewers. Do you think courts should focus more on punishment or rehabilitation? When someone has repeated charges, do they deserve more chances? Or should consequences escalate faster? Because right here, the judge is balancing frustration with opportunity. And that balance is hard to maintain when someone keeps ending up back in court.
On May 20th, 2024, officers conducted a traffic stop near 11540 block of Westheimer Road, Harris County, Texas. After observing the defendant meet with occupants of a white Chrysler 200 and then go back inside the apartment building, the defendant came back outside, walking and concealing something under his shirt as he got into the rear passenger side of the vehicle. Officers identified the male as Nicholas Johnson, one fugitive from an investigation. Upon approaching the vehicle, officers observed the defendant in the front passenger seat and the suspect in the Frike Aurora, he was in the back seat. Upon detaining the defendant, officer observed a large bulge in his front and left pocket and retrieved a pill bottle containing multiple white pills. Defendant stated that the pills were tramadol, 4.8 grams. Criminal history, felony terroristic threat, SBI aggravated assault with a deadly weapon, was convicted August 26, 2021 of the lesser charge, 4 days, felony possession of a weapon, August 26, 21. It was dismissed because of the previous charge, convicted on another charge.
This is a textbook example of how small observations lead to major legal trouble. Officers noticing suspicious behavior, conducting searches, and finding controlled substances are extremely common sequences in traffic stops and street encounters. The discovery of pills becomes serious once ownership is admitted. Confessions or spontaneous statements often remove legal defenses later. And watch the judge carefully. He's not rushing. He's listening, verifying facts, and ensuring probable cause exists. That's the foundation of every criminal case. A key lesson here: what someone says in the moment often matters more than what's later argued in court. Silence protects legal options. Talking removes them. The courtroom may look casual, but every word recorded here can follow a defendant for years.
Attempted possession of a firearm, felony possession of a weapon, 7/6/16. He was convicted 10 months in state jail, felony.
My problem is though, is that they're going and they get wind of him because of another fugitive, right?
No, he was a fugitive.
Oh, Mr. Johnson was a fugitive.
That's according
Don't say
to,
anything, please. You have the right to remain silent. Exercise that right. Anything you say, they're going to sit there type. You'll have a lawyer that'll go to bat on your behalf, and then you guys can make an argument. Okay. So he was a fugitive, though.
according to, that's what I'm reading. Correct.
Because I thought you said it was someone else.
No, Nicholas Johnson. He was the one.
Okay, Mr. Johnson, I'm gonna find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond, don't pick up any new cases. I don't want to have to put you in jail. Just don't. What do you do for a living, Mr. Johnson?
I'm in between jobs right now. I just lost my job at a car wash.
What were you doing?
At a car wash.
So how do you eat now?
This exchange reveals something viewers don't often expect. Judges frequently try to keep people out of jail rather than put them in. But cooperation is required. When the judge talks about jobs and responsibility, he's signaling that continued leniency depends on personal efforts. Courts aren't social service agencies, but they often try to push defendants towards stability. The frustration here is visible. The judge sees someone capable of change but stuck in the same cycle. Courts experience this constantly. Repeated defendants who could succeed but sabotage themselves. This moment shows the emotional tension judges deal with. Protect the public while still giving individuals chances to improve. But chances shrink each time someone returns.
When did you lose your job?
Like 2 weeks ago. It was a week ago. This situation, and that's what I meant.
Talk about the case.
Okay.
I only want to know, how do you survive? How do you get money? How do you eat? How do you pay for rent?
In between jobs right now. I stay with my brother.
You need a lawyer to represent you. How's that going to happen? You need to get a job, a full-time legitimate job. Why is it fair that the citizens of Harris County get to pay for you to get a lawyer for you when you do nothing all day? No.
How bad was not too long ago. I got shot a year and a half ago.
What's happening when you got shot?
Wrong place, wrong.
It's a rhetorical question, Mr. Johnson. But when you hang with dogs, you get fleas. I want you to get a job. I'm now making that a condition of your bond as well. You understand? We're going to give you a reset now. I want you to go get a job and then come back, and then we'll see about getting you a lawyer. No more bumming around doing nothing. You understand? So I'm resetting this case for 2 weeks. When you come back, I want to see what you've done to get a job, putting in applications. I'm telling you, Amazon will hire anyone with 3 legs and a partial heartbeat. Go to Amazon. I'm telling you, they hire everyone. They need more people. You understand? So can you file no weapons, no drugs, no alcohol, and get a job? I'm going to randomly test you, Mr. Johnson. If I find that you're using, I'm going to put you in jail. Understand? So don't worry about it. I'm going to have Anthony take it.
Your Honor, I just want to clarity. It's not clear. It just says that they was positively identified, and it's not clear if they're talking about Mr. Johnson or the other individual, because he does have a felony case, Mr. O'Rourke. So I'm not saying.
That's what I was trying to tell you.
Talking to the judge on the thing. So I just want to make that clear for the record.
If you get a job and it doesn't pay, I'm happy to give you a lawyer. You understand? But I want you to start working, earn your keep. Do you have any kids? What are you doing to support those kids?
Kids are taken care of.
How? You don't work?
My kids are taken care of. So.
The road to hell is paved with good intentions, Mr. Johnson. Kids don't eat with good intentions. Come on.
Chavez, right this way.
See, I'm in the day today.
Hey,
I got you.
come back to like.
Fleming,
Literally just when I started, he's still inside.
she's here.
Yes.
What do you want
I
to do?
instructed her, we're gonna withdraw from her case.
Come up.
Yeah.
She said she will have the past due balance paid later, this week. I've been told by my supervising attorney to withdraw if she gets the.
Just
past-
because you wouldn't withdraw doesn't mean I'm going to grant it. You know what I mean?
Here we shift to a completely different issue: attorney withdrawal and financial obligations. Many viewers don't realize defense attorneys can withdraw if clients fail to pay or cooperate, leaving defendants scrambling mid-case. The judge stepping in shows procedural fairness again. Withdrawal isn't automatic just because payment is late. Courts must ensure defendants aren't left unrepresented unfairly. Then comes the judge's suspicion about possible drug use, prompting immediate testing. That decision isn't random. Defendants under court supervision are usually prohibited from substance use. Any sign of violation triggers testing. This shows how closely courts monitor compliance once someone is in the system. Freedom often comes with strict behavioral expectations. And this moment also reminds viewers, legal trouble rarely comes from one big mistake. It's usually a chain of smaller ones stacking up, and we're only getting started today.
That's why I told her as well.
What's the last name on this?
Kizzy.
Kizzy,
Okay.
Yes.
he's not happy with you. Why?
Because I was late on some payment, so I still have to get my account current, which
You look high now.
I'm not. I'm
She's fresh off work. Your
I'm
Honor.
sending you for a drug and alcohol test right now. That's how you look right now. We'll see. I'm sending you for drug and alcohol test now. As it stands, they want to withdraw from your case.
Yes, sir. I'll have my account concurrent this week. I just got off of work. I'd worked overnight.
Where do you work?
I'm taking care of one of a friend's dementia grandmother.
How much money you make a month?
1,200 maybe. Right as of now, I just got a second job, a serving job as well. So,
Who do you live with? Who do you live with?
I've been, since this whole case happened, I've been staying in like hotels, living, paying for hotels.
Is Anthony still here? Are you, okay. I'm sending you for a drug and alcohol test now. You're not supposed to use anything whatsoever. So we'll see. It's up to you. If you want to withdraw, and we can find out whether she's going to qualify for another appointed lawyer. I don't know. As it stands now, I'm definitely sending you for a drug and alcohol test. Take a seat for me in the jury box.
Thank you, Your Honor.
You would still want me to
Yes,
grant it?
withdraw, please.
Okay, it's early enough that I will for you,
Okay.
okay? I want her drug and alcohol test right now.
Okay.
And then, Stephen, do you mind giving an application in the interim, please? It's Kizzy, it's on the docket today. Sorry, Mr. Rodriguez, how's jail?
Good.
Well, thing is that
Here we pivot into one of the more chaotic segments of the docket: overlapping charges, multiple incidents, and confusion about who did what. And this is exactly how real courtrooms function: messy, fact-heavy, and constantly clarified in real time. Rodriguez is now facing assault bodily injury charges plus a new charge for interfering with public servants. That second charge often comes when someone resists arrest or obstructs officers trying to do their job. Legally, these cases stack consequences quickly. Notice the judge's tone shift: less patience, more urgency. That's because picking up new cases while another one is pending signals escalating behavior. Judges view that as a warning sign. Also pay attention to how the judge insists on sticking to sworn affidavits rather than speculation. Courtrooms don't run on assumptions, and they run on documented probable cause. Engagement question: if someone starts a confrontation but then gets attacked back, who do you think is responsible? The person who started it or the one who escalated it physically? Because this courtroom moment highlights a legal gray zone: confrontation versus self-defense. And courts must carefully separate those lines.
you were charged with assault, bodily injury. Now you've picked up a new case. I don't know what happened on either case. We're going to do probable cause. And so on the assault, you're facing up to a year in jail and or a $4,000 fine. Now your newest case, you picked up an interference with the duties of a public servant. On that one, you're facing up to 6 months and or a $2,000 fine. We'll do probable cause on both, please.
Yes, Your Honor. So officers were dispatched to assault at a gas station in Harris County, Texas. So this video showed complainant, witness talking on the phone. The defendant approached the complainant, got close to his face, then swung multiple times with a closed fist, striking the complainant.
Just out of the random, out of the blue.
Should we go by the, should we go by the affidavit? Should we go by the affidavit, not the DA's breakdown? Because the DIM is a sworn affidavit.
I don't care. We can go by the Wicked Witch of the West, whatever stuff, you know, I don't.
Okay, Your Honor. So, fight continued to the gas station. Complainant was able to hold the defendant in the chokehold until officers arrived. So, complainant felt pain and sustained a physical injury.
So assault occurs allegedly.
Correct.
After that, the complaining witness gets him in a chokehold until the cops arrive.
That's correct. That's what's alleged.
So that's the assault. So what happened next?
This segment shows how quickly street disputes spiral. A confrontation leads to punches, then a chokehold, then police involvement. And suddenly, what started as verbal tension becomes criminal charges. The judge's commentary here is important. Even if someone feels provoked, escalating to violence is rarely justified legally. Courts look at proportional response. Putting hands on someone may justify defensive action, but excessive retaliation can still lead to charges. Notice how the judge dissects tiny details: hand placement, gestures, escalation sequence. Those small elements determine legal responsibility. Court isn't about who felt disrespected. It's about who crossed legal lines. And this moment highlights why emotional control matters. One wrong reaction in seconds can result in months navigating courtrooms.
On the interference.
The new charge, the interference. On this particular case, on the 524 of May 24th of 24, officers were dispatched to a disturbance call located at the address at 7505 Long Point Road, Harris County, Texas. Officer spoke with the defendant, Jonathan Rodriguez, who originally reported being assaulted. After the investigation was complete, charges were declined. But during the investigations, officers, it was discovered that the defendant had a warrant. And it was disclosed to the defendant that he had an outstanding warrant for an assault out of Harris County.
I'll give you a chance.
Upon being told that he was under arrest, the defendant became upset and said multiple times he would not place his hands behind his back. Officers tried to grab hold of the defendant's arms and attempted to place when the defendant pulled away and began yelling at officers, pushing, struggling, preventing the officers from getting him until they subdued him up against the car. He was finally placed in handcuffs and carted off to jail.
Got it. Okay, Trinidad.
So on the first thing, the assault, the DIMS, the sworn affidavit, defendant that gets too close to the complainant's face while talking. The complainant then puts his hand out for the defendant to back up. So that means he had to have touched him. The defendant then began to swing his arms. I mean, furtive motions, that's what we're looking at here for probable cause. It looks like, and then he ends up in a chokehold.
I'm saying, if someone puts their hand out, a reasonable response is not to start swinging.
Close to his face. I mean, what are you doing?
Back away. Doesn't hurt to back away.
And the complainant witness is the baby's or his girlfriend's pissed off baby daddy. Who's
So he goes up, you know that there's gonna be an issue.
You gonna stand up.
Mr. Rodriguez, you know that there's gonna be an issue with just by virtue of who the person is.
Your Honor, I just want to say for clarity, the complainant put his hands to tell the defendant to stay away.
Did he touch him or did he just say, hey man, back up?
No, he did like that. It just says he put his hand up, preventing.
He put his hand up like this. He didn't touch him.
How are we making that up, but we can't make up the other stuff on the other side saying that maybe.
I'm not making up anything.
It's 50-50.
The other thing, all I know is that he's out on the lam.
He didn't know. He's the one that called the law on this new case.
This next case, that was.
He's the one that called. He didn't know that he had a warrant. He would have known that he had a warrant.
So it was a 2B. He didn't know, he had not been arrested, given a PR bond and then got out. Is that what you're
I
saying?
believe that's how it went down.
This part feels almost ironic. Someone calls police for help, only to discover they themselves have an outstanding warrant. It happens more often than people think. Legally, officers must act on active warrants once discovered. It doesn't matter why police were called originally. The judge's commentary reveals another reality. Many defendants genuinely don't understand their legal status, especially if prior court dates were missed or paperwork wasn't followed. This moment shows how unresolved cases linger. Warrants don't expire quietly, they follow people until resolved. And here's the lesson. Ignoring court obligations doesn't make them disappear. It makes future encounters worse. The streets may forget, but court records don't.
And so he's calling the law about this new assault that he's taken, and that's how he gets arrested. That's when they run him for warrants, that's how they get him. So
That's not true. It's not true. He was given a general order bond on 4/16/24, and he didn't show up to his court date. So we issued a warrant for his arrest on 4/23. So homeboy calls the laws when he knows he's got a warrant out for his arrest.
No, he doesn't. He wouldn't have done. Okay, all right. Yeah, you're right. All right. This is the streets out here. Hey, Judge, this is the streets out here. This is true. But I'm just saying, I mean, the PC, I mean, I don't want, if he can do the rip right now, then we can talk to this other fella, baby daddy, to see if there's any issue.
I'm down. I'm down.
Film, we
Have
don't have
nothing else
anything.
to do. So when it dies down, when the line dies down, let's have Kevin go call him and find out what's going on.
Get a ruling.
On what?
Probable cause.
Yeah, I'm gonna find probable cause exists on both cases.
Thank you.
Yeah.
And there it is. Probable cause established on both cases, meaning both move forward. This is not guilt determination. It simply means enough evidence exists to proceed. Viewers often misunderstand this stage. It's not conviction, it's permission for prosecution to continue. From here, negotiations, plea deals, or trials determine outcomes. But the key takeaway is that Rodriguez now faces two separate legal battles. This moment also shows courtroom efficiency. Judges must make rapid yet legally sound decisions repeatedly across dozens of cases daily. And once cases stack up, consequences escalate quickly. Longer sentences, higher bonds, fewer second chances. The courtroom clock never slows down, but mistakes accumulate fast.
Good morning, Mr. Ulloa. How are you? Tell me what you got for me.
I don't have physical proof, but I have proof of my enrollment in GED. The GED class doesn't start
Do
until.
you think you were coming today? The beach?
No. I'm gonna tell you that the GED class doesn't start until next month. But I enrolled.
In this life, you are only as good as the proof that you have. If you don't have proof, you have nothing. So I would like you to get with Mr. D. Show me.
Now we move to GED enrollment. And this moment highlights a recurring courtroom theme. Proof matters more than promises. The judge isn't accusing the defendant of lying. He's insisting on verification. Courts operate on documentation. Verbal claims don't change legal outcomes. Education programs often serve as alternatives to harsher penalties, giving defendants pathways toward improvement. But enrollment must be real, not theoretical. Notice how the judge gives time to provide proof rather than immediately punishing failure to show it. That's an opportunity, not a setback. And this reflects a bigger truth. Courts often provide tools for change, but defendants must follow through. Opportunity exists, but accountability proves commitment.
I showed them pictures of it.
Okay.
So as his attorney, Judge, I would refuse to be in this. My job is to represent, not to incriminate. So.
Has he not given you anything to show?
He's given me information on a line. It does not say Mr. Altroff has been enrolled in this GED. It doesn't say the specifics at all. It doesn't say anything about he has been enrolled. This is to certify that you have been enrolled. There is nothing of that nature.
What do you have, Mr. Ulloa?
I have pictures of me filling out the application, and I have emails saying that the school doesn't start until next month, which is July, which is in a couple of weeks.
Have you seen the document that says that school starts?
I saw that document, saying that school will start at a later date.
You don't think it's legitimate?
I don't know, Judge, but I just didn't see anything that said that he had been accepted in the enrollment, which I thought that would be relevant to your.
The only thing I asked you to do was enroll into a GED program. That's all I asked you to do. Have you done?
Yes, sir.
I want proof. I will not take your word for it. So I will give you, 20 minutes, 30 minutes, somehow print it out, show us that you have proof. And if you need, you can email it to one of us and we can try to print out what you have and I'll take a look and I can call and verify.
Okay.
But I will call now and I will verify it. And I want to ask them and talk to them straight up to see if you have actually enrolled into the DED program. So please step down and give me the proof.
Thank you, Judge.
Thank you, Mr. B. Hi, yes, ma'am.
Good morning.
Hi.
I'm here on Mr. Keelan Felix. We were asking for a reset pending his felony, which will appear on June 21st.
Where's Mr. Felix? Come up, Mr. Felix.
There's also Jason Lucas, his hired attorney who passed. We, Mr. Romero.
Hold on. Come up, Mr. Felix.
Yes, sir.
You picked up another felony?
I just came because we already talked about it. I did all my classes and everything. That's why you put me on the monitor.
Have we addressed that he picked up the new
I'm
felony?
not sure if that's the question. I wasn't sure.
Now things escalate again. Felix is already juggling multiple cases, probation conditions, and now another felony enters the picture. Judges become especially cautious when defendants accumulate charges rapidly. Each new case reduces judicial patience and increases bond risk. Notice the confusion between attorneys and case statuses. That's not unusual. When someone has several open cases, even professionals struggle to track everything. This confusion itself becomes a warning sign. When your legal situation becomes complicated enough that even lawyers are sorting details in real time, life is officially off track. The judge's concern here isn't just punishment. It's public safety and repeated risky behavior involving weapons. And firearms charges tend to eliminate leniency faster than many other offenses.
Since we have the felonies, he's coming to our office today to.
Well, no. He has already a lawyer in this case now with Connor, who's been representing him. So who do you work with?
Mr. Rodriguez. Romero says it's good.
Okay, are you signing on to this case?
That's the idea, yes.
Are you sure? Do you want to reach out to Carlos first?
Yes, an idea is kind of in his hands rather than our hands.
Well, I don't know. I would.
The firm's aware of it. It's just Mr. Felix, whether he wants to go forward.
I don't know. You want to reach out to them to see if in fact that you want to sign on? Because he's got 3 cases with us now.
Yes.
Or I think, no, just 2.
It's 3. One's a deferred judge. It's running concurrent with a 262nd deferred as well. And they haven't filed an MAJ yet, but there's a note that's about to happen, and I don't know if there's one in this court yet.
Did you hear that? Did you hear what he just said? Any minute, they're about to issue a felony warrant because you're on probation in your felony case and you've picked up 3 cases since then.
I ain't pick up 3 cases. I was on probation for it.
I'm just telling you what the prosecutor said. That's all I'm saying, So I don't know.
I'm okay with the public defender staying here for today. We can just ask to go best to become.
Okay, take a seat through in the jury box, Mr. Felix, please. You know where Connor is? I mean, he's still here, right?
He was in and out. He's got a couple more cases.
Okay, great. Okay. On the, so we are going on the 2507-393? Okay. Good morning, Mr. Gutierrez. You're now charged with 2 DWI seconds. You know, the only thing that we want in our country, we want our streets to be safe. Do you know that Harris County leads the nation per capita in DWI fatalities? Guys, keep it down, please. We lead the nation in fatalities. And here you are charged with 2 open DWI seconds.
This moment shifts tone again. Now we're in the DWI segment and the judge becomes visibly emotional. That's because drunk driving cases involve potential innocent victims. DWI second offenses carry serious consequences because repeat behavior signals danger to the public. Judges see aftermaths many viewers never witness: fatal crashes, destroyed families, permanent injuries. Notice how the judge speaks not just legally, but morally. Courtrooms often become places where consequences are explained bluntly, and deportation consequences add another layer. Immigration status can drastically change outcomes in criminal cases. Audience question: should repeat drunk driving automatically lead to jail time, or should treatment programs be prioritized instead? Because courts struggle constantly between punishment and rehabilitation in these cases.
What is it going to take to get through to you? Is it someone dead where you go to prison for 30 to 40 years? Is that what it's going to take? Understand that if you ever come back to this country and you're in a car driving and you get pulled over, an officer is going to see DWI, DWI, DWI. If they smell alcohol, what do you think they're going to do to you?
He said, me va a castigar.
He's gonna punish me. Pero yo ya no pienso volver. But I don't think I'm gonna come back.
I didn't hear you. We'll get there. But if you're caught in a car with alcohol on your breath, what do you think officers will do to you when they see your record?
Cuando vean el récord, que te vean que estás borracho, ¿qué crees que van a hacer ellos? Me van a meter a la cárcel. ¿Y con el prison?
Not jail, prison. From now on, because of your history, you'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. Not only that, you're now being deported to your country of origin. If you come back, the feds can hit you with an illegal re-entry, and then with that, you're looking at a minimum of 5 years in federal prison on that one as well. So I would be very careful if you come back, how you come back, because you could be the next time be facing a lot of time in prison. The only thing we want are streets to be safe. That's all we're asking to do. If you're gonna go drink 15 beers, find another way home. Don't drive. Do you understand?
Yes.
Guys, keep it down. I'm not asking for much. You give up a lot of rights by entering into this agreement, Mr. Gutierrez. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this. Like I told you now, you will be deported. If you come back illegally, you could be facing a lot of time in federal prison. So I would be very careful. Not only that, you get into a car with alcohol, you're going to be facing even more time with up to 10 years. How do you plead to this offense, sir? Guilty or not guilty?
Here we see the conclusion of that DWI matter. A guilty plea, jail credit applied, license suspension imposed. Plea agreements dominate criminal court because trials are time-consuming and uncertain. Defendants often accept deals to minimize risk. License suspension matters more than many realize. Without driving privileges, employment becomes harder, making future stability difficult. And this moment shows how consequences extend beyond jail. Legal penalties ripple into everyday life, work, housing, finances, and family responsibilities. The courtroom decision lasts minutes, but its effects last years.
I will find you guilty, sentence you to 60 days in jail. I'll give you credit for the 30 days, the 32 days that you've done. I'm going to suspend your license for 2 years. Don't drive. Don't drive. Okay.
Hey,
Oh, hold on. Roberto. Case was enhanced.
No, pero si es cierto o no es cierto que tenéis un previo para decir si es cierto.
Is it true or untrue that you had a prior DWI from 2015 here in Court 5?
Es cierto, no es cierto.
True to the enhancement. Okay, good luck. Connor. Hi, bud.
Hey, so approaching on Keelan Felix, apparently the.
Where are we with this case? Because I don't remember.
So we picked up. I mean, me and Pavel were talking about a plea, and we talked about trying to work it out because he does have a UCW and the prohibited weapon.
Hey, we didn't address the new case though, did we?
He was in custody for a while. Yeah, I mean, we addressed the UCW new case. He does have the felony new case as well. But I was appointed last Saturday.
I never revoked. I would have revoked his bond on the new gun case with us after he would have picked up the felony, and I never did that. That's what. Like, come up.
I think, Judge, I think you did revoke the bond. You said it in 3001.
Let me see. Let me make sure. Yeah. Yeah, I did, because it looks like he posted a surety bond on 5/9/24. So, Connor, the question is, what do we need to do to make sure that Mr. Felix doesn't have a gun in his possession? Because apparently 3 open cases is not enough, and a bond of nearly $42,000 is not enough. So what do we need to do to make sure you ain't got a gun in your hands?
I'm doing right, sir. I just did the classes and everything that you
Talk about you doing right. You picked up a felony gun case on 5/2.
But it wasn't even mine.
Perception.
I'm staying out of trouble. You just put me on this monitor.
We return to Felix, and now frustration is unmistakable. 3 open gun-related situations signal serious concern for public safety. Judges lose patience quickly when someone repeatedly encounters weapon charges. That pattern suggests risk escalation, not isolated mistakes. Notice Felix claiming innocence while cases pile up, common in court. Legal truth eventually comes from evidence, not statements. The judge's threat about future bond amounts isn't drama, it's warning. High bonds effectively keep defendants in custody. At this point, Felix's freedom depends entirely on immediate behavioral change. And when judges begin emphasizing employment again, it's because structure is seen as the only path away from repeated court appearances. Felix stands at a crossroads. Change course or expect jail next time.
I'm being watched. You just put me on the monitor 2 weeks.
Is it uncomfortable?
I mean, yes, but I ain't really tripping.
Oh, I'm so
really
sorry, Mr. Felix. Better than being in jail, right? Okay. You're lucky you're not in custody right now as it stands. And I'm going to tell you now, you ever pick up another case, you ever have a gun, I'm going to make your bond so high you're going to split in quads. What's more is I'm telling you, I'm going to drug test you soon. If I find that you're using anything, you know what's going to happen. Now, the question is like, he's got with us, he's on probation he's on deferred for a gun, for discharging a firearm. And then he picked up the gun case with us in December. And now the gun case upstairs. I'm not gonna hold it open forever for the new case to play out upstairs, you know, so.
Judge, I'm
Tell me.
prepared to move forward about it. The thing is, I mean, it's up to you on what we do with this probation. The UCW is an under 21 case and he was 4 months away from being 21. But the probation, Pavel and I talked about doing a time served, just unsat terming his deferred.
And then pleading under the new one?
We didn't talk about the UCW.
New one.
Yes, sir.
So let's do this. Let's set it off just a couple weeks. Have you gotten all the evidence in the new case?
Yes, sir. Yes.
Have you gone over it with Mr. Felix?
I can't, no, I haven't, I mean.
So let's do that.
Okay.
I'm setting your case off for a couple weeks. I want you to meet with Connor to go through all the evidence, and then we're gonna work something so that these are done, so that you can concentrate on what happens upstairs. Okay? The worst thing you could possibly do is pick up, even go near a gun. Don't. Now, what are you doing for a living?
I'm down bad right now. My little somebody just hit my little brother in my car.
Hold on. Are you truly working? Or you just spitting out?
No, I work with my uncle.
What does that mean? I work with my uncle.
From time to time.
Okay, from time to time. So that what? Come on, give it to me straight, Mr. Felix.
It ain't, you know what I'm saying? It ain't no, it ain't, it's just like when he called me, it ain't no everyday job.
Then you must now get an everyday job.
Yes, sir.
I'm resetting your case for 1 week. I want you to see what you've done to get a new job. Go to Amazon. They hire everyone.
Yes, sir. I did the class and everything though, that you told me about. I got you, Mr. Fleischer.
The problem is, Mr. Felix, when you have too much time on your hands, you become self-destructive. That's what's going on. You don't do a darn thing in life. And the problem is that you get caught up in doing.
We hear the employment speech again, and that repetition is intentional. Judges repeat this message because unemployment sits at the root of many repeat court appearances. Idle time often leads back to the same influences, same decisions, and ultimately, the same courtroom. Felix's situation shows a common courtroom pattern. Someone completes programs or classes but still ends up back in trouble because the bigger life structure never changes. Classes help, but stable work changes daily behavior. The judge's frustration isn't just about law breaking, it's about watching someone repeatedly waste opportunities. Courts see defendants with potential who keep sabotaging themselves. Employment provides income, routine, and accountability. Without those, probation conditions become harder to maintain. Audience engagement. Be honest. Do you think getting a steady job actually helps people stay out of trouble? Or is deeper lifestyle change required? Because right now, Felix's future depends less on lawyers and more on whether he can build a routine that keeps him away from guns and bad situations.
Because you ain't got no job. J-O-B. That's the word of the day.
Yes, sir.
Are you unable to control yourself?
Yeah, but you make me nervous.
Good. I'm glad. I want you to get a job. In 1 week, you will be back here to prove to me what you've done. And if you have nothing, it's in my email. If you've done nothing, it's not gonna go well for you. No buts. Get a job. Start looking. When you have too much time on your hands, you become self-destructive. Sometimes we have to save people from themselves because they're our own worst enemy. And that's what's happening. That's what's happening with you. You are your own worst enemy because you have too much time on your hands.
This is one of the most revealing lines in the entire session. Judges sometimes view their role not only as enforcers of law, but as last-stop intervention figures. The judge openly says, Felix is his own worst enemy. That's harsh but accurate in many cases. Courts constantly see individuals whose biggest obstacle isn't police or prosecutors. It's their own choices. Notice how the judge connects free time with self-destructive behavior. Without goals or obligations, people drift into risky environments. This moment strips away courtroom theatrics and shows genuine concern. Judges don't benefit from jailing people repeatedly. It clogs the system and rarely fixes root issues. But intervention only works if the defendant cooperates. Otherwise, jail becomes the fallback tool. Felix is being warned clearly. Next mistake likely means custody, not conversation.
The nice thing about working is not only does it keep your time occupied, but you get money too. And you get to buy nice things like cars, houses, jewelry. Get a job. Got a week to show me what you've done. You're not here going to the beach, so bring proof. That means paper, not palabras or words. Thanks.
Judge, would you be okay with doing a time served on his probation case and unsat terming his deferred?
I don't know yet, because I want to make sure that he's first a working man before we just start pleading and putting more stuff on his record, thereby making you unemployable. The more stuff you pick up, all you're doing is you're making yourself no one is going to give you a job when you keep racking up convictions. You don't get it. The next 40 years of your life can be amazing, or they can be a rotten toilet of an existence, Mr. Felix. And what you're doing now, have you looked in the jail?
Just died like two.
Take a look at how many old people in there. There's a reason, because they ain't got no job. And all they do is they keep pleading guilty. Stop it. You got a week. Thanks, Connor.
Oh, I think we're talking about the thumbs up.
Hey, can you send her for a drug test, please, before it gets too late? Yeah, can we send her now before it gets too late?
Update on Escobar. He's on attempts to know, but that's no in the first attempt.
Okay. All right. It's okay this way, guys. E. Travis Miller. Mr. Miller, you are wanted out of the state of Georgia for aggravated assault and terroristic threats and act. Are you waiving formal extradition, sir? Okay. We wish you the best of luck.
Hey, Judge.
Thank you, sir.
Now we shift to extradition, which many viewers don't fully understand. When someone has warrants in another state, courts temporarily hold them so the requesting state can transport them back. The judge explains it simply. Georgia has 14 days to retrieve him. If they don't, he might be released locally. But the warrant still exists. That means future arrests remain possible anywhere. Extradition cases show how criminal records follow individuals across state lines. Running doesn't erase charges, it just delays consequences. What stands out here is how calm this exchange is compared to earlier drama. Some defendants know their situation is unavoidable and simply accept the process. Courtrooms move quickly between emotional chaos and procedural routine. And in extradition cases, the legal outcome is mostly administrative, but the personal consequences can be huge.
Could you explain the process to me?
So what happens is you have an open warrant out of Georgia for both of these cases, and they want you. So we give them the opportunity to come and get you. We give them 14 days to come and get you. If they don't get you by then, the DAs file a motion to dismiss and then they release you. But understand that just if they release you because Georgia doesn't come for some reason, which they probably will, but if they don't, the warrant is still active. So as soon as you walk out of jail, they can still pick you up and bring you right back to jail because you.
But not in the jail, but on the corner. That's what you're saying.
Right.
Okay.
Right. I mean, you have this warrant open until you go back to Georgia and take care of it. So for the rest of your life, if you never go back to Georgia to take care of it, it's going to be open forever. Okay. But they're coming, right?
Yes.
Georgia has already indicated that they're coming to get you. Okay. Yeah.
Judge, on Mr. Vargas, we're ready whenever you are.
Okay. I lost my translator.
I'll text for virtual again.
Please. Yeah. Hey.
Hey, Judge.
Come on.
I got Brittany Gillardoni. She had a bond forfeited. She's back in custody. She's got a $10,000 bond on her TCS, deferred adjudication upstairs.
Hold on. Let me look it up.
Yeah, well, what I'm getting at is I had done a competency psych eval. She jumped on, so that was never done. I did see, though, we did see that the felony court has requested one as well, but that hearing is not scheduled until like end of July.
On in our case?
Well,
Tell me they gave her a PR bond. Oh,
Well, she's not in the holdover.
$7,504 PR bond.
no. Cannot believe that.
She's not in the hold, well, unless I missed her, I checked in here in court. Gillardoni.
She's here. You must have not answered up to you, but she's here.
She's back there?
She's on the other side, court 8.
No, she wasn't. Oh, court 8. Okay.
I'm gonna say.
She's in court 8.
And I mean, they gave her a PR bond. I can't. She's a super flight risk.
Well, she's not getting out of the felony, just.
Nevertheless, and perhaps that's
Okay,
why.
so do we need to bring her over to, I mean, what are you doing?
We got her, so she's on court 8 side.
But
I'm bringing her, please.
But she never got psyched on my request, and then.
Let me.
Was what she did. It was that she was previously found competent and then she absconded afterwards, but for some reason the felony court have re-requested evaluation, I guess because of the absconding and the fact that they didn't have it at their court. So they made a motion and it was granted by the judge up there, and they just haven't set a date for that competency eval.
Have they set a date or no?
No, they just filed the motion, it was approved, but if there's a date, it's not in the notes.
Oh, I was in the wrong court, so I was in court 6. That's my bad, I thought they were attached.
Right. So she's, for us at least, she's taken off on 3 different occasions, you know?
Okay, and then I do have a trial setting Friday at ERD, but it's gonna plead today. I don't know if you need to know that.
No.
Okay. Just taking a deferred.
It's with us?
It's in your court, yeah.
Is it?
Ovalis, Sharice Ovalis. It's on docket today. Okay, I'm just letting you know. I don't know if it.
Yeah.
Just letting you know in case I take a jury there and then it comes here. I don't know how that works.
Tony, as soon as I get a translator, I'll hit you up, okay? That's the only thing we're waiting on.
No problem, Judge.
Wait, do you want, are we setting it or is he taking a deal?
Yeah, I think we're more than likely going to set it. He's telling me that he might need to get operated on though. So I don't know what the time frame is on that. So let me verify that real quick.
Yeah, I mean, I'm setting it for trial now. I'm not gonna sit here and wait because I don't know what kind of game he's playing. All I know is that's 400 days and I'm gonna set it.
Okay.
You know,
Over there in civil.
it's always something.
5 minutes ago. He said he filed it.
Yeah, but I said it's. So if he does want to take something, let me know so we can get the paperwork written up so you don't have to wait even longer, you know?
Yeah, you filed it wrong and.
Need stipulation, right?
Wait, it just needs a stipulation or the whole thing needs a refile?
Sorry?
It needs just a stipulation or a whole refile?
No, no, just stay right here.
Step forward.
The felony is holding you. You have a $10,000 bond, but apparently. Okay, well, hold on, because judge needs to talk to you.
Yes, I was like,
So I wanted to bring you out because, you know, we're talking about your case. It's only fair that you hear what's going on, okay? Right now, you're on probation for a felon in possession of a weapon. You're also on probation for possession of a controlled substance in the felony case. You picked up in April with us, you picked up an assault bodily injury. You have literally been given 3 PR bonds and you continue to take off.
I didn't get PR bond, sir.
But you have. I'm showing that you failed to appear 516.
I just got a PR bond, sir. Excuse me.
Listen to Dave.
So Roberto, please don't go. Okay, so.
Now we encounter one of the judge's biggest concerns: repeated failure to appear in court. Missing court dates is one of the fastest ways to lose judicial trust. PR bonds rely on trust. When someone repeatedly skips appearances, judges assume future non-compliance. That leads to higher bonds or detention. The defendant insists circumstances caused her return to jail, but judges rely on records, not explanations. This moment shows how credibility matters. Once credibility is damaged, every future decision becomes harder. Judges must balance giving people opportunities with protecting court resources and public safety. And when someone repeatedly disappears, the court eventually stops extending leniency. This exchange highlights a simple courtroom truth: showing up matters. More than excuses, more than promises.
I have 3 different occasions that you failed to appear. I cannot, in my good conscience, give you a PR bond when you continue to take off, because I know if we give you another PR bond, what's going to happen?
I haven't had a PR bond, sir. I've bonded out, and it's the only reason I'm back right here, right now, sir, is because someone took their name off the bond. I haven't did anything else and gotten in trouble. Someone just took their name off the bond because I couldn't get a cosigner. That's the only reason I'm back in jail right now.
I also have that you have failed to appear on 3 different occasions. Okay.
I haven't.
So so what we're doing, regardless, your bonds are set at $55,000 upstairs.
And I'm gonna make the bond this Saturday. That way I can take care of this stuff better.
You make the bond, I am now going to make you wear a GPS monitor so I know where you are at all times, okay?
Yes, sir.
But I cannot give you a PR bond in this case, okay? Because you just don't show up when we ask you to show up. So regardless, you have Greg representing you now. If you do get out, please stay in contact with him. If you get out, you post bond and you jet on me again, Ms. Gilardoni, I'm going to triple, if not quadruple the bond.
Thank
You
you,
understand?
Judge. Yes, sir.
All we're asking you to do is show up.
All
That's
right.
it. And stay out of trouble.
All right.
Okay?
Yes, sir.
I know that the felony courts are trying to have you evaluated as well. Do it, because if you don't, the only thing it does is it prolongs your case even more.
Okay.
Okay?
Yes, sir.
The judge's message here is straightforward. Court compliance is often simple but critical. Many defendants aren't jailed because of violent crimes. They're jailed because they fail to follow procedural requirements. The GPS monitor requirement demonstrates how courts attempt to maintain oversight without full incarceration. Technology becomes a compromise between freedom and supervision. Notice the judge explaining future consequences calmly rather than angrily. He's drawing a line. One more violation, and the bond skyrockets. For defendants, supervision tools like GPS or reporting requirements can feel intrusive. But from the court's perspective, they're alternatives to jail. Engagement question. Would you prefer strict monitoring outside jail or complete loss of freedom inside? Which option actually helps people reform? Because courts constantly juggle these decisions, trying to keep people accountable without overcrowding jails.
I think that we're okay. I don't think that there's.
Oh, Your Honor, thank you.
Yeah. So
I don't think I'm not showing a felony court date for her, but then I was showing.
I am showing 7/29.
Okay, you got that 7/29 felony.
Your court date for your felony cases are July 29th.
Yes,
Okay.
sir.
We don't do that long. Okay, we'll do just 30 days and then we'll come back and then go from there.
Okay, Your Honor, perfect.
Thanks, Steve. Appreciate it. All right, good luck, Ms. Gallardo.
All right, thank you.
Yes, ma'am. So, hey, please. Ixnay, right? Send them out.
That's what time started on the assault.
What is this?
18 days with 6 days, Rodriguez Jonathan,
Okay.
on the 865.
All right, good morning, Mr. Rodriguez. So is this what you want to do?
Yes, sir.
Understand that the assault will go on your record. The only problem is they cannot enhance this to a felony because it's just a garden variety assault, but you will be facing a minimum of 90 days in jail if you ever pick up another assault. So I would be very careful.
Sir.
You give up a lot of rights by entering into this agreement today. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is a final deal today. You can't come back tomorrow and say, you know what, I changed my mind. I want to do something different. It's final today forever.
Sir.
This is what you want to do?
Sir.
How do you plead to the offensive assault?
Good, sir.
I will find you guilty. You're facing a year in jail and or a $4,000 fine, but you guys have worked out an agreement where they're offering you 18 days in jail, credit for the 6. So it's basically, as part of the agreement, the other case will be dismissed as well. Okay. All right. Good luck. Thank you. Take care.
Another case resolves through plea agreement, and again we see how plea deals streamline court dockets. Rodriguez accepts jail time already served, and another charge gets dismissed. That's negotiation in action. Prosecutors, defense attorneys, and judges all weigh evidence, strength, and efficiency. Plea deals often frustrate viewers who expect dramatic trials, but trials are rare. Most cases end exactly like this. Negotiated outcomes balancing risk for both sides. The warning about future assault charges being enhanced matters. Repeat violence leads to harsher sentencing. This moment looks routine, but its impact on the defendant's record will follow him for years. And for the court, it's one more case resolved among dozens that day.
Thank you.
Okay. Thank you, sir. 29. Hmm?
3 days.
Okay. He's got 3 days credit, Tony. You want to do 3-6 or 6-3?
That works, Judge.
Or whatever they offer, I guess. Hey, Kevin, do you mind writing up Vargas for a plea? He's got 3 days credit, so, 6-3, I guess.
No luck, Judge. The only thing that he had sent to the probation office and she didn't receive it was that the next class for GED opens July 24th, something like that. Yeah.
He didn't sign up.
No, sir.
Goes with you.
I signed up, sir.
Come on this way.
Show, where's this? Where is it?
I got the picture. I got the information that I filled it out.
Filling out something is not enough. You have to press send, and you have to get a date, and then you get proof of confirmation that you actually have your name on a class. That's what.
The classes are open until July.
Yes, the classes are open.
We return to the GED situation, and the judge draws a hard line between intention and action. Filling out forms doesn't equal enrollment. This is another recurring courtroom theme. Many defendants intend to improve, but fail to complete necessary steps. Courts require completion, not attempts. Notice how patient yet firm the judge remains. He isn't punishing immediately. He's demanding proof. Education programs often serve as second chances, but without follow-through, those opportunities disappear. The judge's frustration reflects how often courts hear promises without results. This is accountability in real time. Intentions don't count, outcomes do.
Did you sign up to class, and are you actively enrolled? Don't send them down.
Judge, case number is 242-3695. Judge, I wanted to see if you would reinstate the bond. This is the defendant who was on a DFEI divert. They recommended a extension. She needs to pay restitution and have the portable. She has the portable, but just be in compliance with it. She hasn't blown dirty, but she missed some days blowing onto it. So
that means it's as good as blowing dirty. Come up, Ms. Rodriguez.
Judge, she did tell me on Friday she was here. I think she was a little late. They told her to wait outside, and she misinterpreted by leaving. You were here Friday?
Yeah.
What time did you get here?
I got here a little late, not gonna lie. Yeah.
Where did you think you're going, to the beach?
They might have, yeah, so she went outside and she thought.
Court starts at 8:30. It doesn't start at 9:02, 10:51.
I know, I just got in the car.
Number one. Number two, you're on a program that is no tolerance. And now you've done several things that they should, in all reality, just kick you out. The most important thing is to make the other party whole.
Judge, to her part, they didn't give us the form. They didn't email me this form until last week, the restitution form.
Okay, so that you just got wind of it?
You just got it. I mean, literally, and it wasn't part.
Did you know
It
that?
wasn't part of the deal to begin with. they actually emailed me in the middle of this because it was a little, she hit Harris County sign, but it was in the middle of her being in it that they recommended restitution. We didn't get the form until last week.
Okay, how much is restitution?
461.
Okay,
So she didn't know about it when we started.
I understand. Okay, so fair is fair, and it's really not fair to really spring it up on you at the last second, but regardless, the contract says that they can amend it at any time to add additional things. So, you be careful what you sign. When you sign something, you must look and internalize everything you sign, because the document says that they can withdraw from this agreement without, for any reason, if they just because they don't like the way you walk, for example, they can kick you out of this thing. That's what the agreement says.
Now we dive into probation compliance, restitution, and device requirements. These technical requirements often trip people up. The judge explains something critical. Contracts signed in court are binding. Many defendants sign agreements without fully understanding conditions, only to struggle later. Restitution requirements can be added, and failure to comply risks removal from diversion programs. This exchange shows how legal agreements evolve over time, and defendants must adapt. Courts aren't trying to trap people, but rules must be followed once accepted. This is another lesson viewers rarely see. Legal trouble continues long after court dates through probation obligations. And compliance often determines whether someone leaves the system permanently or cycles back again.
The other part of the agreement is that they can add additional things as needed throughout if they learn. In this case here, Harris County wants you to pay back the sign that was broken. I've never personally seen this happen before. This is the first time I've seen it, but that's what they're asking. So one of the things that you'll be required to do is pay back the $460 for the sign that was broken, okay? What else, Shatoria, was?
She did the SOP.
She did the SOP, she did the victim impact. We have no proof that she's completed effective decision making, and we want her to be in compliance with the device in a few months.
My client's adamant she did complete it.
Do you have proof?
I do on my phone, but there was 3 classes that I needed to do, and I did all 3 of them. And then one of the
I
classes.
don't understand. So you didn't do them, but you did them?
No, I did do them. And whenever I had to send over my certificate to my PO, he kept saying that he didn't get it, but.
You have the certificate of completion now? Okay, so we can have you email it to Shatoria, and then assuming that that's legitimate and looks good, then we'll give you credit for it.
She's scheduled to see him on Wednesday, the officer.
Well, but she's here now.
Oh, yes, sir.
Let's take care of it now. I mean, why delay the inevitable, right? I will try to help you as much as I can now, as long as you did it and it's legitimate. If you did, then we'll give you all credit where credit's due. So,
So they were asking for a 3-month extension?
okay. So understand, part of the agreement is they want you to have and be in compliance with the device for at least 2 to 3 months. So is your device currently operational now?
Yeah, my last device, my car stopped working, so that's why I couldn't, well, I wasn't blowing on it, and then.
It was an accident, correct? Very good.
Yeah, but since I couldn't drive it, because they give you like a warning and then they shut off your whole car, you have to like tow it all the way back to Smart Start and then pay it off, but I can't drive the car.
Do you have,
Yeah, I have to.
do you have a portable device now? Really?
Yeah, it's in my purse.
Right, and it's operational. Okay, so you are not allowed to drive any vehicle that doesn't have an interlock on it. Understand, if you're caught driving, I will sprout horns in a tail because I'll be so upset if you drive a car without an interlock. I'm telling you now, the worst possible thing you can do is drive a vehicle that doesn't have an interlock. Don't, because that in and of itself is a death sentence, okay?
Here the judge shifts fully into prevention mode. Ignition interlock devices are one of the most effective tools courts use in DWI cases. They physically prevent a vehicle from starting if alcohol is detected. The judge's strong language isn't exaggeration. Violating interlock requirements is often treated as a serious breach of probation or diversion agreements, sometimes worse than the original offense. Courts view driving without the device as knowingly risking public safety. Notice how detailed the warning becomes. Grandmother's car, borrowed vehicles, anything without the device is off limits. That level of detail shows how often people try to justify small exceptions that later lead to violations. This moment highlights something important. Courts want defendants to succeed, but success requires strict compliance. Engagement question. Do you think devices like this actually help people change behavior? Or do people just wait until restrictions end before going back to old habits? Because here, technology becomes both a safeguard and a test of responsibility.
Truly, don't drive. I don't care if it's grandmother's car that you just found out from 15 years ago. Don't drive any vehicle that doesn't have an alarm. You understand? I mean, because you're looking at me like I think that you are. So that's why I'm saying, don't.
My PO already told me I can't be driving without the alarm.
Can't. I mean, that in and for me, that kills everything instantaneously. So don't. As long as you remain in compliance, we will set you off. It looks like Shatori, does she do everything? It looks like everything is done other than the, what about community service?
That was amazing.
What is it?
Back then when we signed it, Judge, it wasn't one of those mandatory, you have to do it, community service. I think now it is, but back then.
I don't know. But you guys should, what do you think? Is it on there?
From the email I received,
It is
Judge.
on here, and it says 6 hours remaining.
Just from the email I received, it was just decision-making force and being in compliance, and that was from Brenda, who runs the.
She has 6 hours remaining.
I don't think they required it, but
I
I'll
mean,
check.
if any, I do go to a church and help out. I don't know if that's.
I'm okay with that. Really, just get proof. Get proof. Don't bring something on a bar napkin. Make it look legitimate, like on a true letterhead of a church that you're helping out and you're not getting paid for it.
Yeah.
Okay. And I'm okay with that. Okay. So for now, I guess, how long is it going to take you to get the money to pay back the restitution?
I just started working, so in a month. My parents.
How old are
My
you?
mom. My mom and my 3 brothers.
Okay. How old are you?
22, just turned.
Okay. This is the right step because I'm telling you, with the DWI on your record, it will become very difficult to get a job. Your insurance will skyrocket. And are you seeing now how difficult it is? It only gets worse. I promise. You're on the right track. Keep doing well. Keep the device don't get in lockout. And I think you're on the right path. Okay. So set it off 3 months, restitution to be paid off in 30 days. If you ever have any more issues, come back and talk to us. The worst thing you can do is just don't stop appearing. Talk to Brandon. Brandon will come to me if you have any more issues.
In a month, can I get it lowered? Like having to blow on the device?
No, you have to keep the device. That's the most important part as well, that you have the device. We need to make sure that you're not consuming alcohol.
I stopped whenever that day happened.
Well, everybody tells me it's little bunnies jumping in the woods when they're up here in court. And it all changes as soon as they walk out the door. That's why we have the device, to make sure that you don't Jekyll and Hyde us.
Yeah.
Okay? But you're close. You get 2 months, 3 months, and you're done.
And they are.
Just, okay? Okay.
Judge, so her bond, you did revoke.
Oh, I'll reinstate the bond.
This moment is actually hopeful. The judge recognizes the defendant is close to completing requirements and tries to motivate her to finish strong. Courts often see people stumble near the finish line. Compliance fatigue sets in, and small violations undo months of progress. That's why the judge emphasizes staying consistent. Notice how the tone softens compared to earlier confrontations. When judges see genuine progress, they often become more encouraging. The reinstated bond gives her another opportunity, but now expectations are crystal clear. No more mistakes, no more missed requirements. This segment shows the difference between someone spiraling deeper into trouble and someone climbing out of it. The legal system may be strict, but it does reward improvement when it happens.
Okay. Okay. Thanks, guys.
You need case number? Okay, thank you. Thank you. I have a Joe Castillo at 49 to submit to his weekly testing on Mondays.
Okay.
Now, he did not check in with the bailiff. His appearance was not waived today. He's on docket.
Yeah. We had,
Do you want to test him today? Or would
yeah,
you
if he's
rather-
over there, test him now.
Okay.
Yes.
He has 12 negative.
Okay, yep.
We'll test him.
How's jail? How's jail? Tell me. Good. I'm glad that you don't like it. You didn't get the message last time, and I don't know what I need to do. I'm not going to let you fail, Mr. Thomas. And if I have to continue putting you in there, I'm going to do it until you successfully complete this thing. I will not let you get a conviction on your record. You understand?
Now we reach one of the most emotionally charged segments involving Darius Thomas. The judge's tone changes again, stern, but almost parental. Here's the key legal context. Thomas is being steered toward deferred adjudication instead of a conviction. That means if he completes requirements successfully, he avoids a permanent criminal conviction. But missing drug tests and failing compliance risks losing that opportunity entirely. Notice how the judge openly states he doesn't want Thomas to fail. That's significant. Courts often prefer rehabilitation when possible, especially for young defendants. The judge's blunt method, repeated short jail stays if necessary, aims to create accountability without destroying the defendant's future. This is tough love in courtroom form. And Thomas now faces a decision. Accept structure or keep returning to jail.
I don't want you to fail, and I don't want you to end up with a conviction on your record. And if I have to continue putting you over my knee like a little child, then I'm going to do it. Because the last thing you need is to kill yourself at 20 years old. Do you know what you're doing now? Do you know what you're doing? What you and Mr. Duong have, what you're doing? What are you doing? Tell me. Guys, keep it down, please. Speak up, man. Come on.
Classes, community service.
Fees, and you gotta make sure you do it right. If it's a defer, cannot fail it. You have the hearing.
Sorry?
So I can make sure my record is clean, yes, sir.
That's the idea. But you have to fulfill things on your part for it not to end up as a conviction on your record. Why do you, what's wrong? I mean, Mr. Thomas, what's wrong? Tell me. You look all dejected like.
Just trying to understand Darius. I mean, you and I spent a lot of time this morning. He just wanted to make sure that, so just talk to him. He's a very caring person, a very caring judge. We all don't want you to fail, Darius. Okay. So it's tough love is what it is. Okay. So.
Just extra paying bills and all, just staying out the way, trying to stay clean. That's pretty much it. Working 2 jobs.
How do we know? How do we know? You know, you sound all nice and everything now, but when you get out of here, how do we know you're not going to turn? You know, that's my main problem, my main concern is that when you walk out of here today, you're just going to turn into old Mr. Thomas.
This exchange cuts to the core problem courts face. Behavior inside court is easy. Behavior outside court is what matters. Everyone promises change when standing before a judge. But real tests happen once freedom returns and old influences resurface. The judge's concern is practical. Compliance programs, classes, and supervision only work if defendants stay committed after release. This moment shows the gap between courtroom promises and real-world follow-through. Thomas appears overwhelmed, and the judge senses it. Instead of simply punishing, the court looks for ways to create support systems, classes, supervision, structured requirements. But at the end of the day, compliance depends on the individual. Courts can guide, but they can't control life choices once someone walks out the door.
I want you to understand that
No, you're gonna have to do.
so you've got the terroristic threat, the assault, the failure to ID, self-control. Self-control. That's what it's about. What are we doing to make sure that you're going to have a self-control? Is he taking classes?
Yeah, he's gonna have to take some. He's gonna have to take the fifth. He's gonna have
18-week bit.
Well, I haven't confirmed with him, but he's trying to go to either Gabe or somebody to get it down to the online, but he doesn't know for sure. So
who's they?
Damien, State. So
talk to Damien about it.
Well, I have, but he's trying to verify to take it from the 13 weeks down to the 30 to the online class, but he has to get clearance from one of
the default for DVD is it must be in person from the last I know.
Right.
But
Really?
Oh, yeah.
Because the problem is I don't want to set him up to fail. That's a hard thing. And
trust me, Judge, I've been with him over explaining to him, you know, he's got 32 days credit, so they'll give him 90 days for sure, but
no, I'm not going to let you plead guilty.
Yeah, he's
because then you're hosed forever with an assault on your record.
He doesn't want that, Judge. The good news is he's adamant that he's gonna get it all together. I know he's been trying, and I told him he has my number, so we're gonna help get through this. But those are the only things that we can get from the state.
Hey, how do we?
I believe he needs permission from the mayor, but again, I don't. From the
No, he needed from Chief, either Gabe or, oh, I forgot the other one, but so he's trying to run around to get that confirmed.
I mean,
that's what Damien told me this morning, but Gabe is out of town in San Francisco, so he has to run it through the other.
Gabe,
yeah, Kabak.
I don't know how to pronounce his last name.
You know, Gabe. But anyway, he can't help because he's in San Francisco, Judge. So bottom line is he has to get clearance in order to make it a lesser bit.
Can we? You want to do it today and then perhaps modify the conditions later?
Well, yeah, I mean, he's prepared either way, which one, I mean, I told him he's gonna have to, you know, the worst scenarios, he's gonna have to take classes, you know,
Darius,
he's
right?
gonna have to.
The problem is the class they want you to do now. It's called Batters Intervention Prevention Program. It's a class where you have to attend in person once a week for 18 weeks. It's a lot.
Here we see the logistical challenge behind many probation requirements. The Batterer Intervention and Prevention Program requires weekly in-person attendance for 18 weeks. For someone without transportation, money, or stability, that becomes a real obstacle. Courts must decide whether inability or unwillingness causes non-compliance. Notice the judge trying to remove financial barriers by waiving fees where possible. That's significant. Courts sometimes go out of their way to keep defendants from failing due to money alone. But attendance still falls on Thomas. Structure only works if he shows up consistently. This moment reveals how rehabilitation is complicated. Success requires coordination between courts, lawyers, counselors, and defendants themselves. And one missed week can reset everything.
Is that something that you can do? How do you get to point A to B? Do you have a car? No.
I have transportation.
How?
But with the bus.
Who do you have in your life that can help you out?
He's living with his aunt, Judge.
Right now, it's not like.
And one of the things regarding the course is if you miss one, you start over.
Have you talked to Aunt? Have you talked to Aunt
And,
And
well, in the past I have, but not today because I'm trying to get this wrapped up and get him out. And I thought, but yeah, for sure, I'm gonna have to make sure, he's got, well, I don't know if he still has the job, but he had a very good manager that was willing to help him with the Burger King in the ward. So I'm hoping he can go back to that, but that's all he's got, Judge.
Try reaching out. Well, my computer's been rebooting for the last 10 minutes, and so now that I have it up, I can see who the other chief is and give a shout.
I mean, I think Damien understands the situation. I've shown him all the text. He's trying to help, but I think his hands are limited.
do you have access to a computer with the internet?
That phone.
What about it? What about at Ann's house? Ann's house, does she got a computer at home?
No,
Well, no, so she has a laptop.
no, sir.
She doesn't have any computer at home?
She's older. She doesn't really.
How old is she? Oh, Lord, man. So she's not even watching after you, man. She's too old to watch after you? How old is she? Okay, that's not old, man. That's me.
That's
Telling me
younger than
your old
me.
doesn't have a computer.
She just doesn't really. She's not into technology. She's not.
The other option I was going to suggest is we do like an online BIP class. But if you don't have access to a computer, I think the only option we have is for you to do it in person.
There's the library. There's, I mean,
What else is required here besides the BIP?
I think just community service fees, Judge, and a donation, $100, which.
I'm not, he doesn't
No,
have any money.
They told me it was,
I'm going to waive all your fees, so
Yeah.
you're not going to have to owe anything. You will have to pay for the BIP class though, because I cannot pay for that. If I could pay for it for you, I would, but I can't.
I asked about the donation and he told me it was statutory. That was a new one on me today, Judge, but if you can waive it, that'd be great, because obviously the young man needs all the help that we can.
Pay for a BIP class for him.
Yes, but it's gonna be a while, so.
I don't care. I'll pay for the class for you if I can. All you have to do is show up. All you have to do is show up. I'm telling you, if you don't show up, to me, that will be a kick in the ding ding, and I'm not going to be happy. I'm telling you that now. I really want you to do well, Darius. Don't fail me on this, because if you do, all I'm going to do is end up putting you back in jail over and over and over until you get it right.
This line lands with emotional weight. Judges rarely personalize instructions like this unless they genuinely believe someone still has a chance. Thomas is being handed a deal many defendants never get: fees waived, class funded, charges structured to avoid permanent damage. But the judge makes consequences clear: violate conditions and jail returns immediately. This moment shows the dual nature of courts: compassion paired with accountability. The judge essentially tells Thomas, "I'm investing effort in your future. Don't waste it." And viewers should notice how rare this level of judicial patience becomes once defendants age into repeat offenders. This may be Thomas's best chance to turn things around.
I don't want to have to do that. Do you understand? All right. Are both of the other cases getting dismissed or what? Okay. You've got this great deal. Hey, the only thing I want is the BIP class. That's all you need to do is this class. If you can get this done quick, I'll take you off quick in half the time.
So yeah, it's required, 42,504. The $100 is required statutorily now.
Okay. The only thing, you have to pay that per the statute, but I'll take all fees gone, okay?
The donation fee, he has to pay that one.
He has to pay that one, but everything else, no fees. Okay. If you ever have a problem, get in touch with Shatori and she'll help you out. Get in touch with Don. He will help you out. You can always come back and talk to me here. If you take off, I'm going to be so upset. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. You give up the right to appeal. So once you accept this agreement, you're stuck with us forever. Understand, you're entering into a contract with me Mr. Thomas, until you either successfully complete this or you get revoked. I'm not going to do this. I'm going to ensure that you pass this thing. Do you understand? If you violate this thing, I'm going to issue a warrant for your arrest. I'm going to put you in jail, and we're going to see how on earth we can get you to complete this thing successfully. But that's what's going to happen. If we have to continue to put you in jail for a week to 2 weeks, at some point you're going to get it. Do you have any questions? How do you plead to the offense, sir? How do you plead, guilty or not guilty? I will not find you guilty. I will wait until eternity to make sure you get this thing done right.
The judge refusing to enter a conviction here is actually a big win for Thomas. Instead of closing the case with guilt, the court keeps the door open for rehabilitation. Deferred outcomes allow defendants to repair mistakes without lifelong criminal records, but only if they meet obligations. This moment highlights something many viewers miss. Judges sometimes protect defendants from themselves by delaying final punishment. But patience isn't endless. Courts eventually must protect public safety if someone keeps failing. Thomas now carries both opportunity and pressure. His future record depends entirely on choices made after leaving this courtroom.
Good luck.
Yes, sir. Thank you, Judge.
Thank you, Judge.
John,
Judge.
will you get Ann's phone number, please?
Yeah, of course. I have. One other thing, Judge, we've been waiting for Escobar all morning. He's still over there. Apparently, he's not done anything. I just need to.
Go. No, we should zoom in.
You
Go.
just reset him or something.
Well, no, I'm not going to reset him or something.
I'm just saying, like, if he comes back and.
I'll call you.
Yeah.
Let me make sure I have your cell phone. Hold on.
I'll be waiting.
Wow, I can't believe it's this late. Time flies.
All right, Judge, that's it.
All right, we're done. Thanks, Kevin. Good job.
Thank you, Judge.
Anthony, great job today. You did good. So what happened? She just no-showed today?
No, she called in with adequate time, but I didn't get notice until 8:44. So
Okay.
usually when they contact the jails, which is where we have to collect the call outs for the day, they'll let us know by like 6:37. So I didn't get the email with her and like 2 other people until 8:44. So I was intending to.
Turnover sucks so much. You know?
Now, I don't know moving forward what will happen. I actually have a meeting about the new hires later today, so we'll see.
Well, good luck. I'd like to keep you.
If something was to happen, I would request to stay here just for a little and help you out before we.
For sure. That'd be great. Yeah. Until we can get someone.
You know, my preference is court. I deal with a lot with the supervisors all day, but court is nice.
Yeah.
It's a lot more structured. I appreciate it.
Yeah, me too.
But it worked out. So.
Yeah, great. So that's it, right?
Today's courtroom session before Judge David Fleischer shows the legal system operating in its most human form. Messy, emotional, procedural, and sometimes hopeful. We saw defendants facing gun charges, drug possession, DWIS, probation violations, extradition holds, and repeated failures to comply with court orders. But we also saw second chances extended, fees waived, treatment encouraged, and judges trying to redirect people before their mistakes become permanent life sentences in the system. The final outcomes varied. Some pled guilty and served time, others received strict supervision, and a few walked away with opportunities to fix their lives before convictions follow them forever. The broader lesson? Courtrooms aren't just about punishment. They're crossroads where decisions determine whether someone spirals deeper into trouble or steps towards stability. But chances don't last forever. Eventually, consequences catch up. And now we want to hear from you. Which moment stood out the most today? Which defendant do you think will actually change course? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.